Greetings, 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 greetings. It is I, your king, King Clifford Jefferson, the Senator Godfrey, the fifth caravan Jew, son of folk, ruler of Jerusalem, the reincarnation of Jesus Christ, which we know in the English Third Temple Church of England as King Edgar the Peaceful, better known as the King of Peace. It is December 4th, 2023, which is the Berber year 2973. I'm here again with another marvelous lecture for my subjects. Uh, you know, I wish you all well in this grave time that the world is having, but rest assured that your redemption process is near. This video is going to be uh, in regards to another remark that Taj made on his last video called The Miseducation of a Negro. We know in that video he made reference to the English people or those who from England or Albion. He said that they were cave dwellers, as well as he said that they were troglodytes, all right, and that they were pale skinned, white-skinned Caucasians. All right, I disqualified that. He also says that in that same video that he, in the same video, and I explained it in the lesson after that one, which was a lesson saying Taj and Dr. G stop lying to the people about Lombard speaking to the Queen of England, because first of all, whoever Lombard spoke to, if he did speak to somebody sitting in the office of the Queen of England, it was not the Queen of England. It was just a German king sitting on the office of the English king or queen. All right, so let's get that right. And also, he also states in that same video that the Moors were descendants of the Scots, who descended from Queen Scotia. Queen Scotia was the daughter of Nefertiti, so he said. All right, so it's very important to understand that just don't believe what's been told to you off face value. All right, because it's just presumptive. There's no evidentiary fact to validate anything that somebody says without showing the evidence. Without showing the evidence. So we're going to go to that video. I'm going to show a small clip of it just to qualify it, because, like I said, I'm not here to slander the man or talk bad about him. No, I'm not trying to degrade Dr. G or give her the honor that she deserves. All right, but you shouldn't talk about things that you have no knowledge of, because to those who it applied to, it could become off as seeming as derogatory or defamatory. And if that's the case, then justice must catch you. All right. So without further ado, I'm going to get right into the lesson. I'm going to draw off particularly the Dred Scott case. Dred Scott case versus Sanford, because this case was actually decided by Chief Judge Taney. But within this case, it covers the reason why we as a people are identified under this term or classification as Negro, Black, Color, and Ethiopian. And it shows you why those people classified under this term, which was under that status as property, as a result of you not knowing who you were. Okay? You're not knowing who you were. All right. So it's very important to understand that Dred Scott was ignorant about who he was. First of all, Dred Scott had the surname Scott. All right. And the name Scott originated in England, Ireland, and Scotland. All right. It has origins in all three places. All right. So it's very important to understand that you don't believe everything that's said to you. You do some type of investigation to qualify. And to qualify, you must have concrete proof. Not abstract proof, concrete proof. That's what I'm going to give you today. So without further ado, let's get started.
In Iberia, even so, when the people are looking at Iberia, they're not thinking in their mind Moorish, are they? Now, this is back to people not knowing the different attributes and names that belong to them that they think they have no association to. So the advantage of those who are adeptus, they know that our people are hidden in history because they don't know themselves, not because they're actually buried in a hole and branded with a coat of many colors. And so they think that human beings are different colors.
So they don't know the story of Joseph.
Is to make them non-descendable at law.
But these stories sometimes are depictions.
They're allegories.
Allegories for what's going on.
Actuality.
Actuality is with us.
Exactly.
Because like I told you, I for the longest time, all my degrees, theology, I kept wondering, and at the time I wasn't knowledgeable about not being black. But where do black folks come in? Where do we come from? Where do we, where does America, never dawned on me, and never taught.
Yes.
To how to interject. You were just supposed to believe in this stuff.
Now, and then look at here we go again, right? Oxford Dictionary, right? Right? So now let's go through orthology. Right? 8th grade principle, 1800s, right? So now here we go, look. Compound word, right? Now, archaic, which means old, right?
Right.
So it's noun, right?
Right.
But it's a compound word,
Yeah, black.
right? And also in a small case, right? Black, right?
Right.
Uppercase, more.
Right.
So one who can read know that this adjective is not the noun.
Right.
The noun is here, but it's a compound word. So it says what? From black, all even case letters, A plus, which means added, more, capital M-O-O-R, noun. Right after that, see? Adjective, noun. Adjective, noun. Put together, plus.
Yeah.
Connecting, A, unexplained, which means they're not explaining it to you.
Because they don't know.
No, they know what it's not, they're not explaining it, but they're putting it here. A black African, a very dark-skinned person, right? So they're telling
A very dark-skinned person, but I see very dark-skinned in so-called Indians, I was in an Indian store, so-called.
all right. So
today,
the people
and some
think,
of them are, yeah,
so the people think that the adjective is the identity.
right.
More is the identity.
It's a description.
Black is the tag, is the adjective attached to it to
Right.
hide the history. But it's there. The history of who? The real Africans. And all, not some, all of the dark skin. Not some.
Listen,
all.
y'all. Listen.
Now, under a challenge in sociology, as the people start waking up around the world, right? Now you understand what Duarte was saying in the Philippines? Now you see, years ago when Bill Clinton was speaking before, I think the United Nations, and they introduced him. They say, and now the American president, and I think was Fox, Vicente Fox, I think, was president for the United States of Mexico, I think, at that time, and he objected. He says he is not the American president. I'm also the American president. America is a continent. We have a lot of Americans here. He is the president of American corporations, United States of America. And you know how much they didn't blow that up in the mainstream news? But that was set right on the floor of the United Nations when they introduced Bill Clinton as, quote unquote, the American president, because he ain't American. And see, more and more, the Americans, and this is where you have Organization of American States. This is the real Americans, and you, in order to have a voice, and they're always suppressing it. Why? Because they've been falsely promoting their private corporation as a country, and they've been getting that off. That's why Duarte said what he said relative to the Philippines. He says, they call us Philippines, but we're really Moors. And so these things have to be corrected. Why? The nomenclature or the nom de guerre were put in place, known as the brand system, by the hybrid Europeans who conquered the Western Hemisphere to bring the people under what is known as wardship tenures. Write that down, you all. WARDSHIP tenures. That's a military operation. People held the wardship, and this is where the Negro and black tag comes in, and color tag comes in, which are schism operations, military operations, to create schism, or what you call divide and conquer among the true Americans. These is where these terms have taken root in the social structure. This is one of the major arguments that Noble Raleigh made when they spoke to the Queen of England relative to their obligation to the Constitution and treaties, and that these were all what? Brands. and it's not the names of these people.
Okay.
So even
All
when
right. So you heard him say that Nobody spoke to the Queen of England. All right. You heard it right out of his mouth. All right. In regards to the tags and the brands that Dred Scott was under. All right. Dred Scott was subject to the same classification that Todd Sharik and Dr. G are talking about. All right. But have not provided one exemplary or exemplary tool to be able to qualify anything that they're saying in regards to this status. All right. That Noble Jolly went to the Queen of England. All right. But he just said that in the same video that England or English descendants from the land of Angloland or Albion were troglodytes who came out the caves, which happened to be these kings of England who's ruling at this time that Noble Jolly went to speak to about this land. All right. So if he's not English and he went to our soon to be English queen, which was not an English queen, she was a German queen sitting on the English throne, then that means that who is Taj? What's your nationality? All right, if it's not English. And he's claimed to be Moorish American. American is assumed to be the nationality here in America versus Moorish, because we know Moorish is a descriptive term, it's an adjective, it's not a noun. It's descriptive. All right. So let's go back and hear him claim that the Moors are descendants of the Scottish, contrast to English, in contrast to Irish, that the Moors are descendants of the Scottish from Queen Scott, going back to the daughter of Nefertiti. All right. Let's just hear it. Let's go back.
Password phrase of
Listen.
the great quote unquote mixing pot. Those are not circumstantial statements. Mixing pot. They'll say melting pot. That comes from the same thing, but I'm telling you what original. Mixing pot. And then they'll say, they'll do it politically, they'll say melting pot. No, great mixing pot.
So what's
that deal with cooking experiments at Mexico. And then when you see after the Second World War, you know, just like many of you who know the real politics know that Adolf Hitler didn't die in Germany. He died in Argentina in around 1974 in that area. And what do they call it? Patagonia. So I'm throwing things out there for your research so that you're not following the party line of the hybrids who are desperately trying to maintain power, because now the world is on them. So things will be changing very quickly. And for those of you who have a little bit of knowledge about the social engineering, are less distracted, I repeat, less distracted and less apt to be confused about what's really happening. Because remember, as soon as you get into what you call knowledge of the order of the Great Seal, they will start striking. This is why sometimes, I know it's frustrating for some of you, but some of you know that if we say certain things, they will strike down. But we're giving you keys that if you do research, you'll be surprised of what's available to you that you never paid attention to.
But there is a need, and I keep asking you this because those of us who do know also want to know how we can sidestep what the onslaught that's coming, because here we are in this, but not of this.
Mm-hmm. But you need to know how. Now we need to know how that translates into the civil order. You know, a lot of.
But that's important with nation. But yeah. We're not a nation.
We are.
But we are, but we're so fractured. We don't even know.
they're not a nation, but then Todd says, we are. Then she say, as a nation, we are broken up. All right. So which is it? Are we a nation or aren't we a nation? All right. Are we a nation or not? That's the question that they need to ask themselves because they themselves are not sure. And they're supposed to be teaching a nation of people. And that nation is supposed to be called Moorish American, right? You see the flag right there in the background. Now watch what he goes and say.
That's called schism.
Yeah.
No.
We can't stand up and say, no, we're on this side, not that. We're amalgamated.
You need to really get.
Now they're amalgamated. All right. You're going to have to make a choice, whether you amalgamated or not. You got to prove who you are as belonging to a nation, a people. You're going to have to prove that.
Take the point. Now, what do we always talk about, Dr. J? They need to understand and understand when we're saying, and we've done over the years, we've gone over and over, you're talking jurisdiction, not distance. Because the people aren't taught political geography or anthropology. They have been trained in their compressed perspective that foreign means geographical distance only. No, it means jurisdiction. It also means state and state of mind.
Or object. If I'm thinking about, foreign, if splinter goes into my eye, that's foreign. Yeah, it doesn't belong there.
A corrupt thought.
It's foreign.
All right. Okay. De facto.
Foreign.
See, color.
Foreign.
See, now, by people not knowing orthology and etymology, which is, once again, why we even went in this book, just to give a snippet of 8th grade erudition. And also you deal with the alteration into the education system 1902, the part it played. Then when you go into the conquest of Nefertiti's daughters, right? So most of these people don't know that Scotland in that area is Nefertiti's daughters' territory. So in the 1800s, mid 1800s, when they took over England, Scotland, this is why most of the people don't know that the Picts and the Dubs are Moors.
But they show us the movie.
Or our people think it's just a movie.
Yeah, The Last King of Scotland.
Because that's, all right, now you're talking Nefertiti bloodline. See, but when they tell you about Nefertiti, right, what do the people keep thinking? They keep thinking Hikuta on the northern coast of Mexico or Africa, right? So their mind doesn't run to the peninsula, does it? Does it? But what is the real history before socialization?
Stop. So there you hear it. You hear it for yourself. All right? There you see it. Todd's is saying that they're descendants of the Scottish kings through Queen Scotia, all right, which was the daughter of Nefertiti, all right, going all the way back to the Egyptians, all right, the Egyptians. Now that's nationality. You know what I'm saying? That's an Egyptian, that's nationality, all right. Moorish is not a nationality, all right. Scottish, that's a nationality. All right, English, that's a nationality. And we see that Noble Drew and the Moors is claiming to have an interest in both nationalities, Scottish and apparently English, because according to what he just said, Noble Drew spoke to English about the tags. All right. And if he spoke to the English, i.e., de facto English minors about the tags, then he was talking to them about property, because these tags gave us the description of being personal and private property of the master or the owner. Okay? Very, 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 very important to understand that. And we know that the Scottish kings, who claimed to be descendants of Queen Scotia, daughter of Nefertiti, were enslaved to so-called Negro, black, colored, and Ethiopian. All right, under their monarchs. All right. So I don't know if the word foul passed down to become monarch. I don't know. You know what I'm saying? But I know that the Scottish kings have a present in modern history that affects us today, going back to time immemorial, where you claim Nefertiti is sitting down from. Because time out of mind or time immemorial means time out of mind, where memory we can't go back to. All right. We're going to discuss all that today. All right. And prove everything that he said in regards to the people of this land is wrong. What everybody else is saying on their platforms about the people are wrong. What the government are saying about the people are wrong. What the churches are saying about the people are wrong. What the philosophers, theologists, lawyers, scholars, actors, etc., whatever you're saying about these people here in this present territorial, which we call the United States, is wrong. All right? You're wrong. And let's prove it once and for all. Black people. I'm only concerned about those who are identified by that classification, black people. So everybody pull that up. Give me a second. Okay. This ain't no time to be scared, people. No time to be scared. Black is a racialized classification of people, usually a political and skin color based category for specific populations with mid to dark brown complexion. Not all people considered black have dark skin. In certain countries, often is socially based system of racial classification in the Western world. The term black is used to describe persons who are perceived as dark skinned compared to other populations, and most commonly used for the people of sub-Saharan Africa ancestry, indigenous Australians, Malaysians, though it has been applied in many contexts to other groups, and is no indicator of any close ancestral relationship whatsoever. Did you hear that? Whatsoever. So now we can move past that. We also know that American, that has nothing to do with any genealogy or ethnicity. American, that has to deal with your oath of allegiance, all right, to that political society that made you a citizen, all right? For most people, it's through the Naturalization Act of 1790. Then for those, after they stabilize themselves under this new government, It was through the 13th and 14th Amendment. All right, the 13th and 14th Amendment. All right, Dred Scott case going to qualify all this. All right, so let's deal with a couple of things. All right, before we go there. Let's deal with Queen Scotia, the daughter of Nefertiti. All right. In medieval Irish, let me make sure you see this. In medieval Irish Scotia's legends, Scotia is the daughter of an Egyptian pharaoh and an ancestor of Gales. She is said to be the origin of the Latin name Scoti, but historians say she and her alleged ancestors and spouses was purely mythological and was created to explain the name and fit the Gales into historical narrative. Did you hear that? All right. Skoda and the Stone of Scone. The Stone of Scone is the coronation chair that you see used right now in United Kingdom's coronation ceremony. All right. The coronation stone is the stone that originated from Scotland. All right. And the stone was said to be brought over by Scotia at the time of the Exodus when Moses delivered the 12 tribes of Israel from the grasp of the what we call the Egyptian pharaohs. All right. Okay. It's the Baldred Beset is credited with the first to connect the Stone of Scone with Skoda, foundation legends in his 1301 work Procesus, putting forward an argument that Scotland, not Ireland, was where the original Skoda homelands lay. You can also see Comus de Beaumont book, The Great Deception. And then on the cover on that book, it'll show you on the islands of Scotland, Ireland, and England, it'll show you that the names on those territories, i.e. those land masses, refer to those territories belonging to the people misnominated as Negro, Black, Cut, and Ethiopian. And Ireland specifically is labeled or titled Libya. And we know Libya denotes to Berbers. All right. Libya denotes to Berbers. All right. We know that William the Conqueror invaded England in 1066 through what we call the Norman Conquest. And if you look at the year 1066 in the Regnal year, just type in 1066, you'll see that you will have him under the English Regnal year. If you type in 1059, you won't see an English Regnal year, but you do see a Berber king. A Berber calendar. All right. Once again, let me just show you real quick. Come on. We know the Gregorian calendar was created in 1582 by Pope Gregory XIII. We know Pope Gregory XIII descended down from Pope Gregory I, and Pope Gregory I had all the Anglo-Saxons convert to Christianity by way of Pope Gregory St. Augustine of Canterbury had all the Anglo-Saxons convert to Christianity from what we call the Gregorian mission orchestrated by Pope Gregory I, who was the predecessor for Pope Gregory XIII, who created the Gregorian calendar, which we use today. All right. Pope Gregory I aligned the Frankish, the Visigoths, and the Lombardians with the Arian religion, which is called Christianity, which was established through what we call the Church of England. The Church of England goes back to Augustine of Canterbury, which fell into the hands of Henry VIII of the House of Tudors of the Lancaster branch of the Cadet branch of the Plantagenet crown that was established by Godfrey V, Count of Anjou. All right. So as you can see in the 1059 calendar, under the Gregorian year, it's 1059. And the Berber year, the year is 2009. But you don't see an English read now year. You see it? English read now year. So that means the English calendar at that time was the Berber calendar, because you see the Berber calendar is existent at that particular time. And you see all the other concordant calendars from all the other nations, Syria, Balinese, Bengal, Berber, English, Buddhist, Burmese, Byzantine, Chinese, the Coptic, which is the Egyptians, the Scordians, Ethiopians, the Hebrews, Hindu, and all the other ones. They all got their calendar to tell their tale, all right, to tell their story, all right. But we know that Copta, or Queen Copta, parts of Scotia, the daughter of Nefertiti, that means they must have been according to the Coptic calendar, which was a Greek calendar, all right? Because the word Egypt is a Greek word, all right? So let's go back. First, let's go here, 1066. Straight facts. (1066). This is the year. Everybody pull it up. The Berber calendar year is 2016. The English reading that year, who's ruling? William the Conqueror. All right. So if William the Conqueror is assumed to be the first English uh, king, and he was a Saxon, all right. He was a Saxon. He was a Frankishman, all right. We are English. Together we were tried living together until King Edgar the Peaceful came upon the scene and established a peaceful kingdom amongst his descendants. Once he once they established the agnatic succession was based off primogeniture, going back to what we call the kings of Wessex, because at the time of Kent, going back to Ethelbert, that goes to the time when there was nothing more than tribes living together, didn't know who they was at that particular time. They were warned, constant wars going all the way back to our ancient time immemorial, time of the mind, going back to those ancient Berbers, which you now call Egyptians, because they were Libyan Berbers, going back to Shoshin, known as Shishak in your Hebrew Bible. All right, Shishak. He was a Libyan Berber. All right. So let's move forward. Let's go back to Queen Skoda. Barger Beset is credited with being the first to connect a stone to stone with Skoda Foundation's legend in 1301. Next paragraph. Beset wanted to legitimize, you hear this? Wanted to legitimize a Scottish as opposed to English ascension to the throne when Alexander III of Scotland died in 1286. Once again, I repeat, Beset wanted to legitimize a Scottish as opposed to an English ascension to the throne, i.e. the English throne, because the Scots had their own throne. All right. When you say the English throne, you're talking about the corporated soul, you're talking about the crown, which is represented by the king. We already know that. All right. At his coronation in 1249, Alexander himself heard his royal genealogy recited generations back to Queen Scotia. Beset attempted to legitimize, once again, he qualified it, a Scottish ascension by highlighting Scotia's importance as transferring or transporting of the stone of Scone from ancient Egypt during the exodus of Moses to Scotland. In 1296, the stone was captured by Edward I of England and taken to Westminster Abbey. All right. Edward I was of the Plantagenet crown. All right. Let's go to see who this Badar Beset is. For his accreditation or attestation, I should say. All right. Badar Bassett, 1260 to 1311, was a medieval Scottish lawyer. He wasn't an English lawyer, he was a Scottish lawyer. All right. During the Scottish War of Independence, which was in 1296, all right, he was responsible for the Scottish submission to the Papal Create in 1301. Along with his colleague William Frey and William Eaglesham, he prepared his Scottish case for the sovereignty in the face of English claims and aggression by drawing up and modifying the existing literature dealing with the foundation myth of the Scottish people. Did you hear that? As well as those of other inhabitants of what would later be called Great Britain. And with a lawyer's eye, appraising the historical treaties between the two nations, such as the Treaty of Philosophy of 1174 and 1189, time immemorial, and their evolution of repudiation. Because time immemorial goes back to 1189. What was the Scottish War of Independence? The wars of the Scottish, let me make sure y'all see that. The wars of the Scottish independence were a series of military campaigns fought between the Kingdom of Scotland and the Kingdom of England in the late 13th to early 14th century. All right, everyone see that. King Alexander III of Scotland, who we were just talking about, Queen of Scotia, died in 1286, leaving his 3-year-old granddaughter, Margaret Maid of Norway, Northmen, all right, Vikings, and 1290, the Guardians of Scotland, and through the Treaty of Birmingham, agreeing to the marriage of Maid of Norway and Edward Caernarvon, the son of Edward I. All right, the marriage would not create a union between Scotland and England because the Scots insisted that the treaty declared that Scotland was separate and divided from England, and that its rights, laws, liberties, and customs were wholly and inviolably preserved for all times. All right. Now we see in the Scottish independence they were warned with who? Edward I of the Plantagenet crown. All right, of the Plantagenet crown. All right, let me make sure I didn't skip anything. All right, let's go back here. So it says here, with a lawyer's eye appraising the historical treaties between the two nations, such as the Treaty of Philosophy of 1174 to 1189 and their evolution of repudiation. He was deprived of parties of Kinghorn by King Edward I of England of the Plantagenet crown. All right, let's go to the Treaty of Philosophy. The Treaty of Philosophy now look at that territory. Revolt of 1174, 1173 to 1174. Look at the territory that they're covering right about here. Look at all that. All right. This is the Iberian Peninsula that Todd was talking about. Yes, that's the Iberian Peninsula. All right, let's read. Treaty of Philosophy was a forced written agreement made in December 1174 between the captive William I, King of the Scotlands, and Henry II, King of England. Henry II, the son of Godfrey V, Count of Anjou, which my family descent down from. King Godfrey V, Count of Anjou, was the son of Fulk, ruler of Jerusalem. Okay? Let's go down to where it means something. Oh, yeah. During the next 15 years, William was forced to observe Henry's overlordship, such as needed to obtain permission from the English crown before putting down local uprising. The humiliation from William caused domestic trouble for him in Scotland, and Henry's authority extended as far as picking William's Bridge. The treaty was annulled in 1189 when King Richard I, did y'all hear that? Henry's successor was distracted by his interest in joining the Third Crusade, going back to the Crusades, and William offered 10,000 marks sterling, more predisposed to William than his father. Richard drew up a new charter on 5th of December 1189, known as the Quitclaim. You hear that, y'all? The Quitclaim of Canterbury that nullified the Treaty of Philosophy in its entirety. This new written agreement restored Scottish sovereignty, reverting to the previously vague and ill-defined personal tradition of fealty and homage between Scottish and English kings rather than the direct subjugation that Henry demanded. Okay, so we did give him some play. We know that King Richard I, going back to time immemorial, was a descendant of Henry II. And Henry II was the son of Godfrey V, Count of Anjou, which inherited the Duchess of Normandy from William the Conqueror, all right, through the Treaty of Westminster, which I'll go to now. Let me just see. I'm going to go further. Yeah, just read right here. They're still talking about the Treaty of Philosophy. To understand how William came to be captured at Alnwick, one must go back to the question of Northumbria. The seeds of William's discontent were sown on July 1157 when Henry II deprived his brother Malcolm IV, King of Scots, of certain lands and titles that grandfather David I had secured for Scotland from Stephen, King of England. Stephen, King of England, was related to William the Conqueror. All right. He was the brother of Matilda, the wife of Godfrey V, Count of Anjou, which was the control of the Duchess of Normandy. All right. It says the ill-defined border of northern England and southern Scotland have been a matter of dispute depending on the relative power and relationship between the Scottish and English kings in the 12th century. Taking advantages of the English civil unrest during the anarchy, the succession of the crisis between Stephen and Matilda, Henry II's mother, David, invaded northern England on behalf of Empress claim to claim the throne. Okay, that takes me here. Treaties of Westminster. As you can see, all the treaties of Westminster from 1153 to 1674. This one is when Charles, the restoration of the crown, at the sprint of Amsterdam. All right, this deals with all the territories that became crown territory. All right, we know that the charters given from Charles II, the Duke of York, to the profiteers, John Carteret and George Berkeley, were surrendered back to the crown in 1702 under that constitution called the concession agreement. All right, so prior to that, those charters given by Charles, Duke of York, to those profiteers, they were surrendered. They was under the authority of Charles II at the restoration of the crown going back to the first, second, and third, even the fourth Anglo-Dutch War, but takes you here to 1654. 1654 was the Treaty of Westminster with the first Anglo-Dutch War. 1511 and 1527 Treaty of Westminster concerned Francis I from the Kingdom of France and Henry VIII from the House of Tudors of the Lancaster branch. You look that up at your own time. But the main concern here is the Treaty of Westminster of 1153 and the Treaty of Westminster of 1462. The Treaty of Westminster of 1462 was the result of the conflict between the cadet branches of the Yorks and Lancasters, Edward IV and Henry VI, which was the successor of Henry IV. All right, Edward IV was of the York branch of the Plantagenets in the crown, and Henry VI was descended from the cadet branch of the Plantagenet. Henry VI was of the Lancaster branch of the cadet branch of the Plantagenet crown. All right, and the Plantagenet crown, the York and Lancaster cadet branches, was a result of Henry III, who gave birth to Edward I. All right, which gave Scotland their independence in 1296. All right. So as we've seen with the Treaty of Philosophy in regards to the anarchy and the war between Stephen and Matilda, and Stephen was a descendant of William the Conqueror. You know, William the Conqueror invaded Normandy in 1066, all right, as the first English renowned king. Prior to that, the only kings in that territory were kings of the Anglo-Saxon Berbers, all right, because there was no English king. Just for the sake of English, we're not going to throw the baby out with the bathwater, because we know England deals with Angle, and Angle deals with goes back to the term what we call Albion, and we know that Albion, the emperor and chief was Acerton and King Edward the Peaceful, which is our Jesus Christ. All right, so let's move forward. Treaty of Westminster. Treaty of Westminster goes back to what we just talked about, the Treaty of Philosophy. Let me just hear that right quick. I know I talk fast. I got a lot of stuff to cover. Treaty of Wallingford, also known as the Treaty of Winchester, was an agreement reached in England in summer of 1153. It effectively ended the Civil War known as the Anarchy, caused by a dispute over the English crown, not the Scottish crown, but the English crown, between Stefan and his cousin Matilda. The Treaty of Wallingford allowed Stefan to keep the throne until his death, which was to come on October 1154, but ensured that he would be succeeded by Matilda's son, Henry II, whose father name is Godfrey V, Count of Anjou, which is the same name as Jefferson. All right? So if it's called the Treaty of Wallingford in regards to the territorial boundaries, which was all allodial under the crown, i.e. allodial land, going back to William the Conqueror, who invaded Normandy in 1066, and 1066 comes after 1059. And we know 1059, they didn't have an English speaking out here, but yet there were English kings ruling at that time. So we choose to refer to them as English Anglo-Saxon burghers. All right, let's go here. All right, so that brings me here. If it says Treaty of Wallingford, which was the treaty made between Stefan and the Plantagenet crown, Henry II's son, in regard to the territory that was surrendered as a result of the uniting of the Duchess of Normandy with the Plantagenet crown, who was already ruling France at that particular time, who was warned or at odds or with conflict with the Frankish descendants who William the Conqueror descended down from. All right. Let's see. Norman Conquest. Shh, don't come in here barking. Hold on. Get out. Hold on for 1 minute. All right. So, the Norman Conquest. The Norman Conquest was the 11th century invasion and the occupation of England by an army made up of thousands of Norman and Breton, Flemish, and French troops, all led by Duke of Normandy, later styled as William the Conqueror, who's called William the Bastard. William claimed the English throne, derived from his familial relationship with the childless Anglo-Saxon King Edward the Confessor, who may have encouraged William hopes for the throne. Okay, you read it there for yourself. William the Conqueror was descendant of the Carolingian dynasty. All right, we're dealing with the invasion of William the Conqueror in 1066, and his origins goes back to a group of Vikings who were under the authority of the Roman Catholic Church. All right, in 911, the Carolingian French ruled under Charles the Simple, allowed a group of Vikings under their leader Rollo to settle in Normandy. Rollo is the descendant of the Duchess of Normandy, founder of the Duchess of Normandy, where William the Conqueror descended down from. Okay, and he said they were Vikings. You see it here. Carolingians descended down from the Merovingians. All right, it says here. In 1002, the English King Ethelred the Unready, which is the son of Jesus Christ, all right, King Edward the Peaceful, which I'm the reincarnation of. Why? Because I know this history. In 1002, English King Ethelred Unready married Emma of Normandy, the sister of Richard, Duke of Normandy, their son, Edward the Confessor, who spent many years in exile in Normandy, succeeding the English throne until 1042. So we're going all the way back to King Edward the Confessor. King Edward the Confessor, who was the son of Ethelred the Unready, the son of King Edgar the Peaceful, Jesus Christ. All right? We see it. Let's move forward. Norman conquest. All right, we can move forward. I don't want to miss nothing. All right. Okay, let's go ahead now. All right. Let's go to Dred Scott. That's what everybody's waiting on, right? Dred Scott. Let's get there. All right. We know the case dealing with Dred Scott versus Sanford, which is a case held by or overseen by Chief Justice Cheney. All right. Everybody who claims to be scholars knows this case. But before we go there, Dred Scott was not considered a citizen of the United States, nor was he considered a citizen of the state of Missouri. The case was about Dred Scott assuming that he was a free man as a result of being transported to a free state in Illinois by his slave master, all right, who was in the military. Once brought back to Missouri, Dred Scott assumed that he was a free man, and he lost his case in the state court, the appellate court, as well as in the Supreme Court as a result of the Naturalization Act of 1790, all right? The Naturalization Act of 1790 was the statute passed by the congressional, or what they call those who made up Congress at that particular time. And we know at that time, they passed the Naturalization Act of 1790 for those who were classified as citizens under the newfound country under the Articles of Confederation, which involved the original 13 colonies. All right. The 13 colonies were the only ones included in We the People. Y'all need to realize that. The 13 colonies were the only ones included in We the People. All right. Those who were admitted to the Union under Article 4 of the Constitution are not considered originally a part of We the People. All right. There's a jurisdictional limit to We the People. All right. Very important to understand that. All right. So if you're not a citizen of the United States, the next question becomes, are you a citizen of the state? All right. And once again, those that were meant to the Union, you don't qualify. All right. The only one qualified is the original 13 states, which at that time were colonies. All right. They were colonies. Must not overlook that fact. All right. And the main description of citizenship at that time between those on the state who made up at that time as colonies who made up the Confederacy were the only ones who was included in that grandfather clause, free white persons. We must understand that. All right. So let's revisit Emory versus Hassan before we go with the Dred Scott. The decision of the Supreme Court in the United States versus God versus Thing. Make sure y'all see that. This is address. This is the Enway Ahmad Hassan, some Asiatic trying to pass off as a free white person under the National Act of 1790. It says the decision of the Supreme Court in the United States versus Forgot Sing Thing interpreted the statute in question, controlled the results here. All right, control the results here. In those cases, the court held that a statute importing a racial rather than an individual test, the actual color of skin of the particular individual not being decisive, that the phrase white person was generally synonymous with that of the members of the Caucasian race, as properly understood, and that scientific or ethnological classification or races were not significant in the application of that act. In the Thing case, the court pointed out that the framers of the statute in employing the term white person had prominently in mind European peoples. Did you hear that? European people. This is funny. In the Thing case, the court pointed out that the framers of the statute employing the term white person had probably in mind European people who constituted the class from which virtually all of the immigration to this country had come and who really readily became assimilated into our civilization. All right, you hear that? I'm gonna read that again. In the Thing case, the court pointed out that the framers of that statute in employing the term white person had primarily in mind European peoples who constituted the class from which virtually all the immigration to this country had come and who readily became assimilated into our civilization, and accordingly held that the petitioner therein, a high caste Hindu who claimed to be a Caucasian race from a scientific classification based upon remote ancestry, was not eligible for citizenship. The court indicated serious doubt as to whether any people of Asiatic stock could be considered white persons within the meaning of the statute, but left open for the future determination the question of whether some Asiatics might so be clearly related to Europeans as to be eligible for citizenship. Let's move down a little further. To summarize the approach we must follow in deciding whether a particular person applying for citizenship is a white person within the meaning of the statute as interpreted by the Supreme Court, it is necessary to determine whether the particular group or racial subdivision to which the individual belongs. In practical effects, proof of this fact is a matter of genealogy. An individual who presents an aberration from the color of skin of the group of which he is a member, such as a light-skinned Chinese or Japanese or a dark-skinned Anglo-Saxon, does not thereby acquire a different status under the act from another member of that group. So that means that you can claim to be an Anglo-Saxon, but you got to prove it because Anglo-Saxon denotes to being English. All right, that's an ethnicity, that's a genealogy. All right, that's a nationality. Dark skin is just the characteristics of those people who are of that nationality. Just as light-skinned Chinese or light-skinned Japanese or dark-skinned Arabs or Hindu. All right? The first test must qualify. The second test don't qualify anything, just the characteristics of the identification of who that person was. All right? Of course, when an individual applying for a citizenship has a skin of different color, then it's usable for the member of that group from which he claims to come. A strong burden of proof then rests upon him to show by usual methods of proving genealogy that he is in fact a member of that group. You see, in the Naturalization Act, genealogy and ethnicity was not required to be a part of that group because nationality or genealogy or ethnicity was not a factor. After the individual has been traced into that group, the second question which the court must answer is whether the members of the group as whole or white persons as Congress understood the term in 1790 when it was first enacted by the statute. In deciding that latter question, how the statute interpreted, the test is not how the group in question will be classified by ethnologists who had made a study of racial origin, but rather what group of people then living in 1790 with the characteristics then existed when intended by Congress to be classified as white persons. Applying this principle, the court finds that the petitioner is an Arab and the Arabs are not white persons within the meaning of that act. So how clear do you have to be? All right, let's go back to the same thing. Because the idea they had in mind was what they said was European, who assimilated into the group. right here. Let's go here. United States first begot, same thing. This is nothing new. We've been through this already. This is for all those who are slow, who can't keep up. Hence, it seems to require a strong mental effort to sweep into a single category, however elastic, so many different peoples: Europeans, North Africans, West Asians, Iranians, and others, all the way to the Indo-Gangetic plains and uplands, whose complexion presents every shade of color except yellow, from white to deepest brown or even black. But they are grouped together, but they are all grouped together in a single division because their essential properties are one. All right? They say all their essential properties are one. You just said in Ray versus Hassan that all those who they considered European had came over here and assimilated into their group. That's what they said in Ray versus Hassan. Those who missed that, go back and re-see that, or you can watch the video when it's finished. But they are grouped together in a single division because their essential properties are one. Their substantial uniformity speaks to the eye that sees below the surface. We recognize the common racial stamp and facial expression and the structure of the hair, partly also the bodily proportions, and all of which points they agree more with each other than with the other main divisions. Even in the case of certain black or very dark races, such as the Beja, Somali, and a few other Eastern Hamites, we are reminded instinctively more of Europeans or Berbers than of Negroes, thanks to their more regular features and brighter expressions. All right. So even the European, even the free white persons or the Caucasians being classified as Europeans in regards to those who assumed to have come over and assimilated in this continent in that race. All right. They just said right here that they have more in mind as European Berbers. And Europe and the continent of Europe is big as hell. All right. Understand what's being said to you. All right. How we know that? Because Dred Scott case is going to qualify this. Let's go to Dred Scott case. First, I got to pull something up before I forget it. I did this lesson yesterday on my other channel, and then realized it was on there. So I erased it. So I apologize for all those who were viewing that, and then it suddenly disappeared. But I wanted to make sure it was done right, so we done it. All right, this is it. Ah, damn! Why I do that? 1 second. Okay. All right, here we go. First of all, let's go here. Smith versus Alabama. United States Supreme Court. There is no common law of the United States in the sense of a national customary law, distinct from the common law of England as adopted by the several states, each for itself, applied as is local law, and subject to such alteration as may be provided by its own statute. So local law is your municipal law. Understand that. There is no common law in the United States that you call America in the sense of a national customary law, because according to the Nationalization Act of 1790, they are not national. Their system is based off the color of the skin. Okay? Nor are those who are citizens from the 13th or 14th Amendment, because they made you subject to that corporation, i.e., free white person. So you're a property to those free white persons who are not even a nation. There is no common law in the United States in the sense of a national customary law distinct from the common law of England as adopted by the several states, each for itself, apply as its local laws and subject to such alteration has been provided by its own statute. A determination is given a determination in a given case of what the law is may be different in a court of the United States. Let me make sure. This is not where I want to go to. Hold on. I'm too far. Hold on. Bear with me, y'all. Let me just find it. Bear with me, y'all. All right, here we go. Oh, I was there in here. All right. I repeat. There is no common law of the United States in the sense of a national customary law, distinct from the common law of England, as adopted by the several states, each for itself, apply as its local law, and subject to such alteration as may be provided by its own statute. A determination is given in the case of what the law is may be different in the court of the United States from that which prevails in the judicial tribunal of a particular state. This arises from the circumstance that the court of the United States is in cases within the jurisdiction where they are called upon to administer the law of the state in which they sit or by which the transactions govern, exercise an independent though concurrent jurisdiction, and are required to ascertain and declare the law according to their own judgment. This illustration is by a case of Railroad Company versus Lockwood, where the common law prevailing in the state of New York is a reference to liabilities of common carriers for negligence received and a difference of interpretation from the placed upon the judicial tribunal of the state. By the law as applied was nonetheless the law of that state. Let me go back a little further. There is, however, one clear conception to the statement that there is no national common law. The interpretation of the Constitution of the United States is necessarily influenced by the fact that its provisions are framed in the language of the English common law and are to be read in light of its history. The codes and the constitutional and statutory constructions, which therefore is gradually formed by the judgment of this court and the application of the Constitution, the laws and treaties made in pursuance thereof, has for the basis such much of the common law as may be applied in the subject and constitute the common law rested on national authority. Did y'all hear that? On national authority. All right, let's go to Dred Scott. Dred Scott versus Sanford. The federal constitution and the acts of Congress provide for the return of escaping slaves within the limits of the Union. All right, they're talking about the Articles of Confederation. All right, the 13 colonies. No removal of a slave beyond the limits of the state against the consent of the master, nor residence therein another condition will be regarded as an ineffective manumission by the courts of Missouri upon its return to the state. So no matter what state you go to, whether it's free or not, that would not be a condition for manumission. It must be done by an agency. Why? It just said it. Nor can the master emancipate the slave within the state except through the agency of a public authority. The inquiry arises whether the manumission of the slave is effected by his removal, with the consent of the master, to a community where the law of slavery does not exist, in a case where neither the master nor the slave disclose propose to remain permanently, and where both parties have continued to maintain their existing relations. What is the law of Missouri in such a case? In such a case, similar inquiries have arisen in a great number of suits, and the discussion in the state courts have relied upon the subject of much of this similar inquiries have arisen in great number of suits, and the discussions in the state courts have relieved the subject of much of its difficulty. The reason of these discussions is that, in general, the status of civil and political capacity of a person is determined in the first instance by law of the domicile where he is born, that the legal effect on persons arising from the operation of the law of that domicile is not indelible, but that a new capacity or status may be acquired by a change of domicile. That question or status are closely connected with consideration arising out of the social and political organization of the state where they originate, and each sovereign power must determine them within its own territories. A large class of case has been decided upon the second of the propositions above stated in the Southern and Western courts. Cases in which the law of the actual domicile was adjudged to have altered the native condition and status of the slave, although he had never actually possessed the status of freedom in that domicile. Okay, totally contradictory what Smith versus Alabama has said. Okay, which year was Smith, Alabama? That was in 1888. All right, totally different what they say in Smith, Alabama. I do not impugn the authority of these cases. No evidence is found in the record to establish the existence of a domicile acquired by a master or a slave either in Illinois or Minnesota. The master is described as the officer of the army who is transferred from one station to another along with the western frontier in the line of his duty, and who, after performing the usual tours of his service, returned to Missouri. These slaves returned to Missouri with him and had been there for near 15 years in that condition when the suit was instituted. But absence in the performance of military duty without more is a fact of no importance in determining a question of a change of domicile. Questions of that kind depend upon acts and intentions and are ascertained from motives, pursuits the conditions of the family and fortune of the party, and no change will be inferred unless evidence shows that one domicile was abandoned and there was an intention to acquire another. The case first cited denies the authority of a foreign law to dissolve relations with that which have been legally contracted in the state where the parties are and have their actual domicile. Relations which were never questioned during their absence from that state. Relations which are consistent with the native capacity and condition of the respective parties and with the policy of the state where they reside, but which relations were inconsistent with the policy of the laws of the state or territory within which they had been for a time, and from which they had returned, with these relations undisturbed. It is upon the assumption that the law of Illinois or Minnesota was indelibly impressed upon the slave, and in consequence carried into Missouri, that the claim of the plaintiff depends. The importance of the case entitles the doctrine on which it rests to a careful examination. It will be conceded that in countries where no law or regulation prevails opposed to the existence of the consequence of slavery, persons who are born in that condition in a foreign state will not be liberated by the accident of their introgression. The relationship of domestic slavery is recognized in law of nations, and the interference of the authorities of one state with the right of a master belongs to another without a valid cause is a violation of law. So to deprive somebody of their private property is a violation of law, right? And slaves were considered property, all right? But they're considered property. At that time, yes, the common law of England was in place, but we were not considered Englishmen. We were considered property. They were not considered Englishmen. They were considered colonists. If they were not considered colonists, they were considered foreigners. We know colonists and foreigners are one and the same. And we know they're one and the same because they don't have the nationality that they have prior to the land that they originated from. As such a case as the original 13 colonies under the Articles of Confederation, First and Second Continental Congress, known as the free white person or the white Caucasian class, which has nothing to do with a nationality, a nation, a country, ethnicity, or genealogy, or even deriving from relationship with God. Because they separated church from state. Let's move forward. The public law of Europe formally permitted a master to reclaim his bondsman within the limits period, whenever he could find him. And one of the capitularies of Charlemagne abolished the rule of prescription. Did you hear that? Once again, one of the capillaries of the Charlemagne abolished the rules of prescription. He directs that whatsoever within the bounds of Italy, either a runaway slave of the king or of the church or of any other man should be found by his master, he should be destroyed without any bar or prescription of years. Yet upon the provisions that the master be a Frank or a German or of any other nation foreign, but if he be a Lombard, them same Lombard, Visigoth, and Frankish that were under the control of Pope Gregory I, who had all the Anglo-Saxons convert to Christianity by way of invasion, it clearly says here, or Roman, he shall acquire or receive his slavery by the law, which he has been established from ancient times amongst them under the law what they call prescription. The law of prescription. How many of you know what the law of prescription is? Because I talked about that all the time. I talk about it all the time. Hold that thought. Make me some coffee because this is about to get good. There I go. Okay. All right. So it says that, but just repeat. This is Dred Scott. The public law of Europe formerly permitted a master to reclaim his bondsman with a limit period, wherever he could find him. He, in one of the capitularies of Charlemagne, abolishes the rule of prescription. He abolishes the rule of prescription. He directs that whatever within the bounds of either the runaway slave of the king or of the church or of any other man should be found by his master, he should be restored without any bar or prescription of years, yet upon the provisions of that the master be a Frank, a German, or of any other nation foreign. But if he be a Lombard or a Roman, he shall acquire or receive his slave by the law which he has been established from ancient times among them. This is called time immemorial. All right? That's called time immemorial. Without referring for precedents abroad or to the colonial history for similar instances. You hear that? For similar instances. The history of the Confederation and Union affords evidence to attest the existence of this ancient law. You hear that? So they recognize the ancient law of prescription going back to Frankish, what they say? Frankish German? What was it? Frankish Germans, and these are the ones who enslaved us, all right? These are the ones that the Scottish kings made alliances with. Called the Old Alliance, right? Right when Scottish got their independence from the English kings, all right? Frankish and the Scottish kings had alliances, all right? Like they still have today. America and Frankish have alliances. Why? Because those same kings who gave America their power are still the ones behind it today. And it's not the English. Why? Because we're the English, the ones, the power they're using. They're using our own power on us. All right. So it says here, yeah, let me stop right here. Prescription. So everybody needs to know what prescription is, all right? Because the European countries understand it, and the founding fathers will recognize it, their understanding about prescription based off this ancient law, all right? Based off the ancient law, they recognize it, all right? From ancient times. It starts from ancient times amongst them. Let's get a qualification. What is that? Adams, Letterman, Bailey, New York real estate attorney. These are receipts. I bring receipts. I'm leaving no rock I'm leaving no rock uncovered, not uncovered. Every rock is being uncovered. Every rock. No one's gonna be able to hide. All right. All right. It says here, as a real estate litigator, these have been some exciting times for practitioners and trying times for the developers. We compare these times to the Duchess touches New York soil for the first time, the heart of Brooklyn, Queens, and the Bronx. We have run into paper streets, easements for trains, tracks, never built, plans for communities that went into a different direction, and desired use for land never contemplated or approved until recently. As a result of the desired development, encroachment and record obstacles have had to be reckoned with. Let me read that again. As a result of the desired development, encroachments, and recorded obstacles have had to be reckoned with. In addition, as further results of this Wild West type land rush into areas not previously subject to massive development, the number of prescriptive easement cases have bloomed. You hear that? How many of you know what prescription easement is? All right. Under the common law, one American court has placed the origin for gaining a right of prescription in English law at a point anterior to the memory of man, but which at one time was fixed at the year 1189, the commencement of the reign of Richard I the Lionheart. It eventually became a settled principle of the common law that such an enjoyment for the term of 20 years raises a legal presumption that the right was originally acquired by title. The right of use acquired with the prescriptive easement is typically a right of passage over to the land from passage over the land from into another property or to the public thoroughfare, but is also extended to the right to use certain features of the land in common with the landowners and other or third parties. For example, hunting or property or fishing or swimming in lakes or streams or building abutting the property. So this is called the public trust. All right, this is called the public trust doctrine. You must understand that. It was something else I wanted to point out as well. Where is that at? Oh yeah, it also public trust doctrine that goes into what we call the cess tu que. All right, the cess tu que is called the public trust. All right, and we know, as I said, in the state represented by the Attorney General to railroad company, Standard Oil Company, it said that when land is seceded, it automatically is when there's no heirs, it becomes interstate, which means that all property is streets to the crown. All right, to the crown. If it's bona vacatia, the states hold it as what they call abandoned property, which King it says in that case that when there is no heir, that King is less to gain the public trust. All right, because he's holder of the public trust. Look at that case. All right, I think we'll briefly go through it in a second. All right, so even the real estate attorneys are recognizing the origin of the common law. All right, in lieu of prescription, right, and what we call prescription of use, which is what we call easement, a non-possessory right and use of property that you don't own. You don't own. All right, let's define prescription first. Prescription of sovereignty. Prescription in international law is sovereignty transfer of a territory by the open encroachment by the new sovereign upon the territory for a prolonged period of time, acting as the sovereign without protest or other contest by the original sovereign. It is analogous to the common law doctrine of easement by prescription for private real estate. That article you just read is what they're doing. They're using prescription by easement. And easement means a non-possessory right to use property that you don't own. All right, you don't own. Let's see. Easy proper prescription. Let's define it. Yes, we do it all. We do it all here at the English Third Temple Church of England. We do it all. Easement is a non-possessory right to use or to enter onto real property of another without possessing it. It is best typified in the right of which in a right of way in which one landowner A may be enjoyed over a land of another B. An easement is a property right in the type of incorporeal property in itself at common law in most jurisdictions. All right. There we see it right there. Let's go here. Says to quay. cessu quae. Besides the obvious limitations placed on the cessu quae by the statute of mortmain, the statute of uses, the statute of wills, and its legality was shaped indirectly by the provisions within the Magna Carta and Queen Imperatrix. Queen Imperatrix was passed by who? Edward I, the one who gave Scotland their independence. All right? Through the Scottish independence. All right? All these were still in place. They're in modern day statutes in New Jersey right now. Queen Imperatrix. I showed you in my last podcast. For the sake of time, I'm not going to show you this time. Let's move forward. All right. Prescription. So we know an easement is a non-possessory use and property that you don't own. All right. That's what you call a deed. All right. It's not an instrument of ownership. It's an instrument of use. All right. Let's move forward. Prescription. The doctrine legalizes de jure and the de facto transfer of sovereignty caused in part by original sovereigns' extended negligence and or neglect of an area in question. Did y'all hear that? Neglect of an area in question, a sovereign neglecting the area which in question, which originated with who? The Scottish kings sitting on the English throne, which caused the insurrection in the first place. Did y'all hear that? The Scottish kings stop the demise or the transfer of the crown by interregnum as a result of what we call the English Civil War or the War of the Three Kingdoms. All right? Let's prove it. Prescription Act. This is by William II and III, a Scottish king. All right? A Protestant. Sitting on the English crown. The Prescription Act of 1832, an act of Parliament of the United Kingdom concerning English land law, and particularly the method for acquiring easement. All right? It didn't say Scottish land law. It didn't say Irish land law. It said English land law. Okay? English land law goes back to the Norman conquest because that's when fiddle tings were given out. All right? That's when fiddle tings were given out. You know what I'm saying? We already went into the Norman conquest when fiddle tings were given out. We're going to go through it in the Dred Scott case in a second. I just want to read prescription because Dred Scott also made or denoted to what they call the law of prescription, which is recognized by foreign countries and the Confederation that was consisted of your founding fathers, Madison and the other one. We'll get back to that in a second. History of the Prescription Act. Common law, the prescription assumed continuous prescriptive rights from 1189 when the legal regime officially began, all time before which had been designated as time immemorial. Did you hear that? Time immemorial. So what is time immemorial? Okay. What is time immemorial? Very important because Dred Scott case is going to talk about the public trust under Johnson versus McIntosh, and Johnson versus McIntosh is going to talk about time immemorial. All right, going back to King James, and King James was the Scottish king who gave rights to colonists over here. All right, and Dred Scott case is going to make the distinction between a colonist, which was a slave, and a subject of the king. Dred Scott is going to make the distinction between the two. All right. Time immemorial is a phrase meaning time extended beyond the reach of memory, record, or tradition, and indefinitely ancient. Ancient beyond the memory or record. The phrase is usually legally significant content as well as a common parlance, like they was just talking about as we read in what was that Prescription Act. All right, as they read in the prescription, time out of mind. In law, So when you use this time in the mind abstract, then you go back into the talk dealing with the Native Americans. And Native Americans have said under the public trust doctrine of Johnson versus McIntosh and Martin versus Waddell that the Native American Indians were only mere occupants of the land. The land belonged to the crown. All right. So in law, according to time immemorial, in law, time immemorial denotes to a period of time beyond which legal memory cannot go, and time out of mind. Most frequently, the phrase of time immemorial appears as a legal term of art in judicial discussions of common law development in the United States, the property rights of Native Americans. You hear that? The property rights of Native Americans. English and American common law, time immemorial is frequently used to describe the time required for a custom to mature into the common law, right? Common law is a body of law identified by judges in judicial proceedings rather than created by a legislator. Judges determine in the common law by pinpointing legal principles consistently reiterating in previous legal cases over a long period of time. So that's why I'm using these cases. All right, it's called stare decisis. And English law, time immemorial ends and legal memory begins at 1189. The end of the reign of King Henry II, son of Godfrey, the fifth Count of Anjou, is where my surname is descended down from. All right, who is associated with the invention of the English common law. Did you hear that? Because common law is found to have a non-historical immemorial event. It is distinct from the laws created by a monarch or legislative body on a fixed date. In English law, time immemorial has also been used to specify time required to establish prescription right. The Prescription Act of 1832, which we're just reading, which we'll go back to in a second, which noted that the full expression was time immemorial, or time whereof the memory of man was not to the contrary. So most of you forgot that history in regards to time out of mind, going back to your rights of property that subject to prescription, i.e. easements. All right? As a result of the trust cess-tu-que that was put on your behalf until you woke up. Until you woke up. All right? American law inherited the English common law tradition, just as Smith versus Alabama has said. All right? Unlike English law, American law does not set time immemorial. So they did away with the term time immemorial because they know the term time immemorial, according to law, goes back to that time era dealing with Richard I. All right? And Richard I was the son of Henry II, the one or the inventor of what we call common law, which America calls stare decisis or case law. Yeah, I'm bad. Believe that. I'm bad. Let's get it. Prescription Act, 1832, which was just mentioned. Contents of the Prescription Act of 1832, passed by William III II, Scottish king, whose successor was Queen Anne. All right, Queen Anne was under the authority of the crown. All right, as a queen. All right, that's king and parliament. All right, that's a fusion of government that was here in New Jersey in 1776 under the New Jersey Provincial Council, under the New Jersey Constitution of 1776, that declared under Article 22 of the Constitution that it preserves the common law of England and a trial by a jury. And we know, as stated in Jones versus Freedom, which we read, in regards to succession of territory seceded to the United States, because he says that in regards to tariffs, and tariffs are taxation dealing with international or foreign trade, import and impulse. All right, dealing with that, it clearly says that those cases ought to be tried by the Anglo-Saxon trial by jury courts. All right, and we know that Anglo-Saxon trial by jury court goes back to the time of Ethelred the Unready, the son of our Jesus Christ, King Edgar the Peaceful, which I'm the reincarnation of. 1 second. I'm doing the class, bro.
Oh, okay.
All right, gotta go. All right. It says here, claims the right of common and other profit pretenders not to be defeated after 30 years enjoyment by merely showing the commencement after 6 years enjoyed the right to be absolute unless had to be consent or agreement. All those who are reading this, you can read it on your own. I'm just going to go to each point for the sake of time. Point 2. And claims the right, way, or other easements appears to be 20 years and 40 years. You can read that on your own time. Claim to the use of light enjoyment for 20 years. They talking about light. Presumption to be allowed in claims here provided. Presumption at law means that those who will bring forth the claim by provided by facts, evidence. Presumption at law. Point 7, provisions for infants. Most important one is the last one. What time to be excluded and computed the terms for 40 years appointment by this act. All this deals with reversion and remandment of the estate. All right, that's what that deals with. I'm gonna go to the last one. It clearly says that this act not to extend to Scotland or Ireland. Did you see that? This act is not to extend to Scotland and Ireland. We know Scotland and Ireland united with England and in 1707 Treaty of 1707, Union of the Crown, part itself, the Union of 1707. All right, that's when they united with England. But we see this act was passed by England, not Scotland or Ireland, and it said that Scotland and England are not included in the Prescription Act for the right of the prescription. All right, right of use, right of easement. All right, it can be done lawfully or it can be done unlawfully. We know that, as the attorney said it in this case right here, they're doing it unlawful because their easement or use does not go back to the time of Richard I. All right, of Lionheart. There it goes back to the time of the modern states descended down from the Confederate states, descended down from the colonies, who were at that time subject to the monarchs of England, who didn't have a right to prescription or use. That's why they gave it back in 1783 under the Treaty of Paris. They gave it right back to the crown. The crown has always been here. You don't believe me? Let's go back to Dred Scott. Hold that thought for a second, everyone. Back. Without referring, make sure y'all see that. Without referring to precedents abroad or to colonial history for similar instances, the history of the Confederation and the Union affords evidence to attest to the existence of this ancient law. Did you hear that? The Articles of Confederation is validating or attesting to this ancient law. In 1783, Congress directed General Washington to continue his remonstrances to the commander of the British forces respecting the permitting Negroes belonging to the citizens of these states to leave New York, and to insist upon the discontinuance of that measure. In 1788, the resident minister of the United States at Madrid instructed to obtain from the Spanish crown orders to its governors in Louisiana and Florida to permit the faculties that apprehension of fugitive slaves from states promising that the states would observe the like conduct respecting fugitives from Spanish subjects. Okay, let's go here for a second. Dale Limmer versus Bedell. All right. This case deals with the territory of Puerto Rico. All right. Puerto Rico was one of the first slave ports in the world. Yes, Puerto Rico. All right. That's why it's called Rich Port. All right. It says right here. This case was dealing with uh, tariffs. All right. And we know tariffs deals with foreign trade, and foreign trade was prohibited by the crown upon the colonies that were subject to the crown at that particular time. All right. And in this court ruling, it ruled that the port of New York or New Jersey, which goes back to what we call the New Jersey and New York campaign and the Philadelphia campaign, going back to the time of George Washington, all right, against the British Empire at the time of the Revolutionary War, all right. It deals with the laws that forbidded foreign trade. And in this case, in 1901, it ruled against the Port of New Jersey for taxing Del Limmer Sugar Company in regards to those tariffs. All right. So as you can see, it clearly says right here, moreover, the limitation of the Constitution apply there as here, requiring the same taxes, duties imposed, and excise to be collected, and the same Anglo-Saxon system of a trial by jury is to be used. Their people become at once our people, citizens of the United States. Our ports become their ports, our market, their markets. They are free to come here to sell their products here, while our taxes and our laws, however unsuitable, must go there. That goes back to the Revolutionary War dealing with tariffs, taxation, the Sugar Act, the Stamp Act, the Townsend Act, the 1770 Act on the taxation on the colonies. All that deals with the taxation that was imposed by the British monarch at that time, which were all Scottish descendants. All right, we must understand that. Let's move forward. What they say in Jones versus Freedom before we move forward. Jones versus Freedom was a case dealing with Virginia. All right, dealing with the de facto officers holding positions of the government consisted of the House of Representatives and the Senate. All right. This is what they said. Jones versus Oklahoma. 1944 case dealing with territory called Oklahoma, which didn't come to the Union until 1901. All right. Prior to that, it was considered Indian territory, and the Indian territory first was discovered by the Kingdom of France under what's his name? Saint Francis King Francis what's his name? King Francis the First. That's his name. King Francis the First from the House of Capet. All right. Everybody got to know your history. Let me find it. Where is it at? Here we go. It says here, the United States should guarantee to every state in the Union a republic form of government and should protect each of them against invasion on the application of the legislature or of the executive, which the legislature cannot be convened against upon itself. The United States should guarantee to every state in the Union a republic form of government and should protect each of them against invasion on the application of the legislature or of the executive when the legislature cannot be convened against domestic violence. That in all probability, domestic violence as a result of chaos would ensue if a de jure or de facto legislature cannot be convened. That means government shutdown, breakdown. Anglo-Saxon civilization afforded a rule of law, rex natquam matier, which means the king never dies. And to avoid such chaos and violence, the constitution of every state at Smith, Alabama was enacted, which honors the common law of England as the municipal law and must be looked at in light of its history. All right? It said it. Let's go back to Dred Scott versus Sanford. So George Washington received instructions from the Kingdom of Spain, right? And back to that case, Dilemma, what's it called? Dilemma versus Bidwell, which was the case in Puerto Rico. Puerto Rico was succeeded to the United States by the Treaty of Paris with Spain. All right, but Spain already had a treaty with Great Britain in 1763. All the territory that Spain and France had was ceded to Great Britain. All right, so how come Spain making new treaties with the United States in the 18th century, dealing with that case, Dilemma versus Bidwell? Case was in 1901, as I said. All right, Dred Scott, let's commit it. Let's continue. So it said here, in 1783, Congress directed General Washington to continue the remonstrances to the commander of the British forces respecting the permitting of Negroes belonging to the citizens of these states to leave New York, and to insist upon the discontinuance of that measure. In 1788, the residence ministers of the United States at Madrid was instructed to obtain from the Spanish crown orders to the governors of Louisiana and Florida to permit and facilitate the apprehension of fugitive slaves from the state, promising the state would observe the like conduct respecting fugitives from Spanish subjects. The committee that made that report of this resolution consists of Hamilton, Madison, and Sedgwick. All right. And the clause in the federal constitution providing for the restoration of fugitive slaves is a recognition of this ancient right. Another principle that a change of a place does not affect a change of a condition. I repeat, a change of a place does not affect the change of a condition. The dimension of the power of a master to reclaim his escaping bondsman in Europe commenced in the enactment of laws of prescription. There's that word again, prescription, and we know prescription goes back to time immemorial, going back to Richard I. And Richard I was the son of Henry II, the inventor of the common law, which is called case law in this present day. All right? So the United States, under the Articles of Confederation, recognizes ancient law of enslavement. All right? They recognize the ancient law of enslavement because slaves were property. And it all deals with property, whether it was personal, movable, or non-movable property. All right? The dimension of the power of the master to reclaim escaping bondsmen in Europe commenced in the enactment of the laws of prescription in favor of privileges communes. Bremen, Speyer, Worms, Vienna, Ratisbon, and in Germany, Carcassonne, Béziers, Toselo, and Paris, and in France, requiring privileges on this subject at an early period. The ordinances of William the Conqueror that a resident of any of the civil population of England for a year and a day without being claimed in a city, borough, wall, wallet town, or castle of the king should entitle them to perpetual liberty and a specimen of these laws. The earliest publicists who had discussed this subject emboldened a jurist of the 16th century whose work quoted in the early discussion of the courts in France and England on the subject. He says, in France, although there be some remembrance of old servitude, yet it is not lawful here to make a slave or to buy anyone of others, and so much as the slaves of a stranger. So soon as they set their foot within France, become frank and free, as was determined by an old decree of courts of Paris against the ambassador of Spain, who had brought a slave with him to France. He stated another case which also arose in the city of Tosolo of Genoese merchant who had carried a slave into the city in the voyage from Spain. And when the matter was brought before the magistrate, the procurator of the city, out of the record, showed certain ancient privileges given unto them at Dosali, wherein it was granted that the slaves, so soon as they should come into Dosali, should be free. This case was cited with much approbation and discussion of the claims of the West Indian slaves of Verdeland for freedom, and in 1738 before the judges in Admiralty, and were reproduced before Lord Mansfield and the cause of Somerset, and in 1772 of the case cited by Bowden. It is to be observed that Charles V of France exempted all the inhabitants of Paris from serfdom or other feudal incapacities. And in 1371, and this was confirmed by several of his successors. All right. This is way back in 1371. All right. The decisions were made upon special ordinances or charters which contained positive prohibitions of slavery, and where liberty had been granted as a privilege, and the histories of Paris furnished but little support for the boast that she was a sacrosancta civitas, where liberty always had an asylum, or for the self-complacent rhapsodies of the French advocates in the case of Verdeland, which amused the great lawyers who argued the case of Somerset. The case of Verdeland was decided upon special ordinances which prescribed the condition on which West Indian slaves might be introduced into France and which had been disregarded by their master. The case of Somerset was that of Virginia slave carried into England by his master in 1770. Who remained there for 2 years. For some cause, he was confined on the vessel destined for Jamaica, where he was to be sold. Lord Mansfield, upon the return to the habeas corpus, which is a prerogative writ, stated the question involved. Here, the person of the slave himself, he said, is the immediate subject of inquiry. Can any dominion, authority, or coercion be exercised in this country according to the American law? He answered, the difficulty of adopting the relation without adopting it in all its consequences is indeed extreme, and yet many of these consequences are absolutely contrary to the municipal laws of England. So if this is the case, then Smith, Alabama said all the states of the Union adopted the common law of England, which must be looked at in light of history. So you don't know this history, this is why you are considered a slave, just like Dred Scott. Because he was enslaved by the Scottish kings sitting on the Scottish throne as the soon-to-be corporation sold, but they were nothing more than accurate corporations. All right, spooks. Again, he said, the return state that the slave departed and refused to serve, whereupon he was kept to be sold abroad, so high an act of dominion must be recognized by the law of the country where it is used. The power of the master over his slave has been extremely different in different countries. The state of a slave is of such a nature that it is capable of being introduced on any reason, moral or political, but only by positive law, which preserved its force long after the reason, occasion, and time itself for whence it was created, or erased from the memory, i.e., time immemorial. If you not understand the laws of time immemorial, then you subject to positive law. All right, and positive law is the laws created by slavery. It is so obvious that nothing can be suffered to support it but positive law, that there is a difference in the system of states which recognize and which do not recognize the institution of slavery and cannot be discussed. Constitutional law, punitive law, police, domestic economy, industrial pursuits, and amusements, the modes of the thinking and of the belief of the population of the respective communities all show the profound influence exerted upon the society by this single arrangement. This influence was discovered by the Federal Convention and the deliberation on the plans of the Constitution by Mr. Madison, which observed that the states were divided into different interests, not by their difference of size, but by other different interests, not by their difference of size, but by other circumstances, the most material of which resulted from a climate, or principally from the effect of their having or not having slaves. So they needed slaves. Remember, under the tariff law, the United States, only way they can make money is through the Tariff Act of 1789. Because prior to that, the only trading that was done was domestic. All right, and the slaves were domestic slaves. All right, domestic slave was okay, but international slave trade was not, because that was reserved for the British monarchs. All right, i.e., the Scottish kings who were sitting on the English throne, which Tatri said he descended down from. All right, going back to Nefertiti, which was a Coptic queen. All right, made to look like us. Let me see, go back. John Matz observed that the states, I read that already. These two causes occur in forming the great division of the interests of the United States. The question to be raised with the opinion of Lord Manfield, therefore, is not in respect to the congruity of the two systems, but whether slavery was absolutely contrary to the laws of England. For if this was so clearly, the American law could not operate there. Smith versus Alabama. Historical research ascertains that at the date of the Norman conquest, the royal population of England were generally in a servile condition, and under various names denoting slight variations in condition, they were sold with the land like cattle and were part of its living money. Traces of this existence of African slaves are to be found in the early chronicles. The Parliaments in the time of Richard II and also of the time of Henry VIII refused to adopt a general law of emancipation. Why? Because they were practicing the slave trade. Act of emancipation by the last name monarch and Elizabeth are preserved. African slave trade had been carried out under the unbound protection of the Scottish crown, not the English crown. The English crown was being usurped by de facto rulers. All right. For the near 2 centuries when the case of Somerset was heard, and no motion for its suppression had ever been submitted to Parliament. Why? Because there was a war between King and Parliament at that time. While it was forced upon and maintained in unwilling colonies by the Parliament and the Crown of England at that moment, that was a lie. It was not the English king. There was Scottish king sitting on the English crown under the office of the English crown, which was at that time de facto. All right, 15,000 Negro slaves were then living in the island, where they had been introduced under the counsel of the most illustrious jurors of that realm, and such slaves have been publicly sold for nearly a century in the markets of London, in the northern parts of the kingdom of Great Britain. Great Britain only came in 1707. All right, they ain't going back to the time of the true English heirs and successors who did not practice slavery. There existed a class from 30,000 to 40,000 persons, of whom the Parliament said in 1775, many colliers, coal heavers, and salters are in a state of slavery or bondage, bound to the colliers' salt works, where they work for life, transferable with the colliers and salt workers, where their original masters have no use for them, and whereas the emancipating or setting free the colliers, coal heavers, and salters in Scotland, you hear that? In Scotland, who are now in the state of servitude, gradually and upon reasonable conditions, would be by means of increasing the numbers of colliers, coal heavers, and salters to the great benefit of the public, without doing any injury to the present masters, and will remove the reproach of allowing such a state and servitude to exist in free country. That's why when I started this video, you heard the song playing where the so-called Negro blacks and niggers were working on the railroad, singing about freedom. All right. And again, in 1779, they declared that many colliers and coal heavers still continue in a state of bondage. No statute from the Norman conquest till the 15th George III had been passed upon the subject of personal slavery. Did you hear that? Did you hear that? And America got their independence from who? King George III. Let's go here. The decision of Lord Manfield was so high an act of dominion as the master exercised over his state and sending him abroad for sale could not be exercised in England. Under the American laws and contrary to the spirit of their own, the decision of Lord Stowell is that the authority of the English law terminated when the slaves departed from England, that the laws of England were not imported into Antigua when the slaves upon her return, and that the colonial forum had no warrant for applying a foreign code or dissolve relations which had existed between persons belonging to the islands and which were legal according to its own system. There is no distinguishable difference between the case before us and that determined in the Admiralty of Great Britain. Let me go to where I want to go. It is fair. It is that new state may be admitted by the Congress to this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any other state be formed by the junction or two or more states or parts of the state without the consent of the legislature of the state concerned, as well as Congress. This is Article 4 of the Constitution, all right? The Congress shall have power to dispose and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution to be so construed as to prejudice any claim of the United States or of any particular state. They're talking about secession. It conceded in the decision of this court that Congress may secure the rights of the United States in the public domain, provided for the sale or sale of any part of it, and establish the validity of the title of the purchaser, or may organize territorial governments with the power of the legislation. But the recognition of the preliminary powers of Congress to dispose of the public domain or to organize a government or over it does not imply a corresponding authority to determine the internal polity or to adjust the domestic relations of the persons who may lawfully inhabit the territory in which it is situated. A supreme power to make needful rules respecting the public domain and a similar power of framing laws to operate upon persons and things within the territorial limits where it lies are distinguished by broad lines of demarcation in American history. The court has assisted us to define them in Johnson versus McIntosh. And Johnson versus McIntosh. First, let's go to Martin versus Wardell before we go to Johnson versus McIntosh. All right? In closing. This is Martindale versus Wardell. In the case of Johnson versus McIntosh, this court said that according to the theory of the British Constitution, all vacant lands are vested in the Crown as representing the nation, and the exclusive power to grant them is admitted to reside in the Crown as a branch of the royal prerogatives. We see in United States versus United States Fidelity Corporation versus Carter, which I'll show you the King's prerogatives are still active in 1933 in Virginia. Where's it at? Right here. Supreme Court of Virginia, United States Fidelity Company versus Carter. One, preference, common law, prerogatives of the king. From the very early times, the common law of England, as stated in Smith v. Alabama, gave or rather recognized the king's assertion of a right by prerogative to have a debt due to him, i.e., a tax, by one of his subjects, paid in preference to a debt due by his debtor to one of his subjects. So you're going to pay the king before you pay the king's subject, all right? This right existed regardless of the solvency or insolvency of the king's debtor, and it was not limited to the collection of taxes, duties, and other revenue, because we know tariffs deals with the raising of revenue, all right, through foreign or international exchange, imposts, and imports. Common law prerogative writs existed at the time of common law adopted by Virginia. As to the king's prerogative right of preference, there can be no question that both in the 4 years of the reign of James I, a Scottish king, all right, they ain't talking about the James the king, they're just talking about the king itself, all right. James, the natural person, is different from the station which he sits in as the king, which is a corporation soul, which means it's perpetual. It never dies, as stated by Holdsworth in the Sesquique, all right. As to the king, prerogative rights or preferences, there could be no question that both in the 4th year of reign of James I and also at the time of the American Revolution, the king was entitled by prerogative under the common law of England to have the payment of a debt, public or private, due to him preferred to the payment of a debt due by his debtor to any of his subjects, regardless of solvency or insolvency of the debtor. All right, let's go back to Sesquique. I'm surgical, y'all. I think it's in here. I could be wrong. All right, for the sake of time, I'm gonna move forward. All right, let's go back to Dred Scott. All right. But the recognition of plenary powers of Congress to dispose of the public domain or to organize government over it does not imply corresponding authority to determine the internal polity or just domestic relations of the persons who may lawfully inhabit the territory from which it is situated. A supreme power to make needful rules in respecting the public domain and a similar power of framing laws to operate upon persons and things with territory limits where it lies are distinguished by broad lines of demarcation in American history. This court has determined this by Johnson versus McIntyre. But first, we go to Martin versus Waddell. In the case of Johnson versus McIntyre, the court said that according to the theory of the British Constitution, all vacant lands are vested in the Crown as representing the nation, and the exclusive power to grant them is admitted to reside in the Crown as a branch of the royal prerogative. And this principle is fully recognized in America as in Great Britain. All the lands we hold were originally granted by the Crown, or our whole country has been granted, and the grants purport to convey the soil as well as the right of the dominion to the grantee. Here, the absolute ownership is recognized as being in the Crown and to be granted by the Crown as the source of all titles. This extends as well as to lands covered by the water, as to the dry land. Otherwise, no title could be acquired to land or water. There is, in this case, no intimation that any of the lands are vested in the Crowns as trustees, but as absolute owner. All right? Absolute owner. Statute of mortmains. If land under the waters can be granted and are actually granted The grantee must, of course, acquire all the rights to the use and enjoyment of such lands of which they are susceptible as private property, as much so as the dry land, and there can be no grounds for any implied reservations of ungranted rights in the one case more than in the other. And the grant of the soil carries with it, of course, all the uses to which it may be applied, among which is the inclusive of several fisheries. All grants of lands, whether dry land or covered with waters, are for the great public purposes, subject to the control of the sovereign power of the country. So the grant of the soil under the waters which carries with the several fisheries is subject to the use of the water for the public purpose of navigation and passing and repassing, but is nowhere laid down as the law of the land that the several fisheries is a part of the just publicum and open to the use of the public, so long as the fishery remains ungranted. It is the common and may be used by the public, but when granted to individual, it becomes private property as much as any other subject whatever. And I think the law is too well settled that a fishery may be subject of a private grant to be at this day drawn into question. If then, according to the principles of the common law, Smith v. Alabama, the king had the power to grant soil and under the waters of the navigational stream, where the tidal ebbs and flows, and if ebbs and flows, and the self-grant of soil carried with its right of the several fisheries to the exclusion of the public use. The remaining inquiries are whether the grants of Charles II to Duke of York in this year 1664 did convey the premises in question, and if so, then whether the rights were surrendered by the properties of the Jersey to Queen Anne in 1702? This charter to Duke of York is one containing not only a grant of the soil, but of the power of government. This court, in the case of Johnson versus McIntosh, is noticing the various charters from the crown. Observe that they purport to convey the soil and the right of dominion to the grantees. In those governments which were dominated royal, where the rights to the soil were not vested in individuals but remained in the crown, or was vested in the colonial government, the king claimed and exercised the right of granting the land. Some of these charters purport to convey soil alone, and on those cases in which the power of government as well as the soil are conveyed to individuals. The crown has always acknowledged itself to be bound by the grant, and in some instances, even after the powers of the government was revested in the crown, the title of the properties of the soil was respected. The Carolinas was originally proprietary government, but in 1721, a revolutionary was effected by the people, who shook off their obedience to the proprietors and declared their independence immediately unto the crown. And the king purchased the title of those proprietors who were disposed to sell. Lord Carteret, however, who was one of the proprietors, surrendered his interest in the government, but remained his title to the soil, and that title was respected till the Revolution, when it was forfeited by laws of war. This shows the light in which this charges granted the soil was considered by this court, that they will convey an absolute interest in the soil and pass everything successful of private and individual ownership, and which fisheries is certain on according to the settled law. By this authority I have referred to, subject always as before mentioned to the just publicum or rights of navigation and trade, but of that which right of common fishery forms no part after the soil has been conveyed as private property. All right, in closing. All right, let's go to Johnson versus McIntosh in closing. We know what time immemorial is, right? Everybody know what time immemorial is from the law. Johnson versus McIntosh, also mentioned in the Dred Scott case. First, that on the 23rd May of 1609, King James, the Scottish king, remember, prescription does not apply to Scots and Irish descendants. All right? It just said it. And dealing with prescription act going back to time immemorial. All right? We know time immemorial goes back to Richard I, son of Henry II, son of Godfrey, the 5th Count of Anjou. All right? That on the 23rd May 1609, James I, King of England, by his letter patent of that date under the Great Seal of England, did erect, form, and establish Robert Earl Salisbury and others, his associates, in a letter patent name and their successors into a body corporate, a politic by the name of the style of the Lord Treasurer Company, adventure and planters of the city of London for the first colony of Virginia, with perpetual succession and power to make, have, and use a common seal, and to give, grant, and confirm until this company and their successors. Under certain reservations and limitations in their letter patent, express all lands and countries and territories situated lying and being in that part of the North America called Virginia, from the point of land called Cape or Point Comfort, all along the seacoast of the Northwest 200 miles, and from State Cape or Point Comfort, all along the seacoast to the southwest to 200 miles, and all that space and circuits of the lands lying from the seacoast of the present aforesaid up into the lands there out from the sea and west and northwest, and also that all the islands lying within the 100 miles along the coast of both sea and of the present aforesaid, with all the soils, grounds, rights, privileges, and appurtenance to the territory belonging in the letter patent, particularly enumerated. All right. And did grant to these corporations their successors, various powers, and the government in the letter patent, particularly express that the place called in this letter patent Cape or Point Comfort, and this place now called and known by the name of Old Point Comfort in the Chesapeake Bay in the Hampton Roads, and then immediately after the granting of the letter patent, the corporation proceeded by the virtues of them to the possession of part of the territory which they described, and to form settlements, plant a colony, and to exercise the power of government therein, which colony was called and known by the name of the colony of Virginia. Third, that at the time of granting these letter patents of the discovery of the continent of North America by Europeans, and during this whole intermediate time, the whole of the territory in the letter patent described, except a small district on the James River where several of Europeans had previously been made, were held, occupied, and possessed in full sovereignty by various independent tribes or nations of Indians, who were the sovereigns of their respective portions of their territory and the absolute owners and proprietors of the soil, and who neither acknowledge nor own any allegiance or obedience to the European sovereigns or states whatsoever, and that in making settlements within the territory in all of the authority parts of North America, where settlements were made under the authority of the English government or by its subjects, the right of soil was previously obtained by purchase or conquest from the particular Indian tribes or nations by which the soil was claimed and held, or consent of such tribes or nations was secured. That in the year 1624, this corporation was dissolved by a due course of law, and all the power together with its rights of soil and jurisdiction on the letter patent in question were revested in the crown of England, whereupon the colony became a royal government with the same territorial limits and extent which had been established by the letter patent, and so continued until it became free and independent state, except so far as the limits extent was altered and curtailed by the Treaty of Paris of February 10, 1763, between Great Britain and France by the letter patents granted by the King of England, by establishing the colonies of Carolina, Maryland, and Pennsylvania. Fifth, the sometime previous to the year of 1756, the French government laid its claims to the countries west of the Elahi or Appalachian Mountains and on the Ohio and Mississippi River and their branches, took possession of certain parts with the consent of the several tribes or nations of Indians possessing and owning them, and with the like consent established several military posts of settlement therein, particularly Kaskaskias, or the river of Kaskaskias, and at Vincennes, or in the river of Wasbash, within the limits of colony of Virginia, as describing and establishing it by a letter patent pursuant to May 26, 1609, that the government of Great Britain, after complaining of these establishments as encroachments and the police powers, remonstrating against them at a length in the year of 1756, took up arms to resist and repel them, which produced a war between the two nations, wherein the tribes of the inhabitants and the holders of the country northwest of the Ohio and on the Mississippi above the mouth of the Ohio were in allies which were allied with France. And the Indians, known by the name of the Six Nations of the Iroquois, the civilized tribes, and their tributaries, allies, were the allies of Great Britain, and that on the 10th of February, 1763, this war was terminated by the definitive treaty of peace between Great Britain and France and their allies, by which it was stipulated and agreed that the river Mississippi, from its source to the Eberville, should forever after from the boundary between the dominions of Great Britain and those of France is that part of North America between their respective allies. This is why it's called British America, which is part of the British Empire. 6. And my grandfather and my family come from Mississippi, which was under the territory of Louisiana. 6. The government of Virginia at and before the commencement of this war, and at all time after it became a royal government, claimed and exercised jurisdiction with the knowledge and assent of the government of Great Britain, and over the country northwest of the River Ohio and east of Mississippi, as being included within its bounds and limits, described the establishment for that colony by the letter patent of May 23, 1609, that in the year 1749, a grant of 600,000 acres of land within the country northwest of Ohio and as part of Virginia was made by the government of Great Britain to some of its subjects by the name or style of the Ohio Company. This is being parceled out, all right? It's being parceled out. 7th, that the act and before the commencement of the war of the 1756, during the whole continuance of the time of the treaty powers of February 10, 1763, the Indian tribes or the nations inhabited the country northwest of the Ohio, of east of the Mississippi, as far east as the river falling to the Ohio called the Great Miami, were called and known by the name of the Western Confederacy of Indians, and were the alliances of France and war by not her subject, never having parts. So let me read that again. Let's drop back here. I know I'm reading fast. That at and before the commencement of the war in 1756, and during the whole continuance, and at the time of the treaty on February 10, 1763, the Indian tribes or nations inhabiting the country north or northwest of the Ohio and east of the Mississippi, as far east as the river falling into Ohio, called the Great Miami, were called and known by the name of the Western Confederacy of Indians, and were the allies of France in the war, but not her subjects, never having been in any manner conquered by her, and held the country in absolute sovereignty as independent nations, both as to the right of jurisdiction and sovereignty and the right of soil, except a few military posts and a small territory around each, which they had ceded to France. And she held under them, among which were the aforesaid posts of Cascassius and Vincennes, that these Indians, after the treaty, became the allies of Great Britain, living under her protection as they had before living under that of France, but were free and independent, owing no allegiance to any foreign power whatever, and holding their lands and absolute property, the territories of the respective tribes, being separated from each other and distinguished by certain natural marks and boundaries to the Indians well known, and each tribe claiming and exercising separate and absolute ownership over its own territory, both as to a right of sovereignty and jurisdiction and the right of soil. This is called a claimant right. 8. That among the tribes of Indians thus holding the inhabited the territory north and northwest of Ohio, east of the Mississippi and west of the Great Miami, with all the limits of Virginia as described in the letter patent on May 23, 1609, where certain independent tribes or nations called the Illinois or Cascassius and the Piankashaw or Wabash Indians, the first of which consisted of three several tribes, united into one called the Cascassius and the Piwarians, and the Cahoquias, that the Illinois owned, held, and inhabited as their absolute and separate property, a large tract of country within the last mentioned limits and situated on the Mississippi, Illinois, Cascassius River, and on the Ohio below the mouth of Wabash, and the Piankashaws, another large tract of country within the same limits, and as their absolute and separate property on the Wabash and Ohio River, and that these Indians remain in the soil and absolute ownership and possession of the country in question until the sale made by them in manner herein set forth. Check it out. 9. That on the termination of the war between Great Britain and France, the Illinois Indians be by the name of the Cascassius tribes of Indians, as fully representing all the Illinois tribes then remaining, made a treaty of peace with Great Britain and a treaty of peace limits and amity under her medium with the Six Nations or the Iroquois and their allies, then known and distinguished by the name of the Northern Confederacy of Indians. The Illinois being a part of the Confederacy, then known as distinguished by the name of the Southern Confederacy and sometimes by the Western Confederacy. 10. that on the 7th of October of 1763, the King of Great Britain made and published a proclamation for the better regulation of the countries ceded to Great Britain by the treaty, which proclamation is referred to and made part of the case. 11. That from time immemorial, look at that word, time immemorial, and always up to the present time, all the Indian tribes or nations of North America, and especially Illinois and Pinkishaw, and other tribes holding possession inhabiting the said countries north and northern of Ohio and east of Mississippi and west of the Great Miami, held their respective land and territory, each in common individuals of each tribe or nation holding land and territories of such common with each other, and there being among them sole separate property in the soil and their soils method and their sole method of selling, granting, and conveying their land, whether to governments or individuals, always had been from time immemorial, and now is for certain chiefs of tribes selling to represents that the whole tribes in every part of the transaction to make the contract and execute the deed on behalf of the whole tribe to receive for the consideration, whether it's money, commodities, or both, and finally to divide such consideration amongst the individuals of the tribe, and that the authority of the chiefs so acting for the whole tribe is attested by the presence and action of the individual composing the tribe of some of them, and by the receipt of the individual composing the tribe of their respective shares, or the price of the price in no other manner. So as we can see, the term time immemorial, and let's go back to the term time immemorial. Because we see Johnson versus McIntosh, Martin versus Waddell, Dred Scott versus Sanford. We know that under the public trust doctrine, that all land remains under the public trust, as we've seen in the state under Representative Attorney General Parson against Standard Oil Company, which is a company established by the Rockefellers, which were a corporation. So it says in closing, time immemorial is a phrase meaning time extending beyond the reach of memory, record, or tradition, and indefinitely ancient. Ancient beyond memory or record. The phrase usually legally significant context as well as in common parlance. So in law, time immemorial denotes a period of time beyond which legal memory cannot go, and time out of mind. Most frequently, the phrase time immemorial appears as a legal term of art in judicial discussions of common law development. And in the United States, the property rights of Native Americans. Notice the distinction. The discussion involves common law, and we know Springfield, Alabama, all the states adopted the common law of England and must be read in light of the history of the common law. So if that's the case, then you must be read in the light of the English and American common law. Because it said time immemorial is frequently used to describe a time required for a custom to mature into common law. Medieval historian Richard Barber described this as a watershed between primary oral culture and a world where writing was paramount. Common law is a body of law identified by judges and judicial proceedings rather than created by a legislator, meaning that this is what they live by. When these people vanished or disappeared, they kept a record in which the judges make their depositories and deposit and deposit them in the depositories, which is the judiciary books. All right. In English law, time immemorial ends and legal memory begins at 1189, i.e., which is the first, which the real estate attorneys have qualified. All right. When legal memory ends, in English law, time immemorial ends and legal memory begins at 1189 and the end of the reign of King Henry II, who is associated with the invention of the English common law. All right. And that's subject to the Prescription Act, where it says that Scotland and Ireland does not partake of that. And King Henry II is the son of Godfrey, as we see here. Father Godfrey Plantagenet the Crown, who married Empress Matilda. All right. Godfrey Plantagenet married Empress Matilda. And going back to, where was that? Scots. Where's it at? Treaty of philosophy. Treaty of philosophy. All right. Treaty of philosophy. All going back to the Stone of Scone, going back to Scoter, Queen Scoter. All right. Says the treaty was annulled in 1189 when King Richard I, Henry's successor, was distracted by an interest in joining the Third Crusade. We know that a trust or attest is what? This is funny. Right here. Both certificates are rooted in medieval law, a legal device for avoiding feudal services due to an overlord by granting land for the use of another, one who owed none of these to the Lord. The law of certificate tended to defer jurisdiction to the courts of equity as opposed to the less flexible common law court. The device was often used by people who might be absent from the kingdom for extended time as a crusader or a business venture. Okay? Who held the tenancy in the land and returned old feudal incidents, i.e. service, which we call free and common soakage. Okay? So there you have it, cut and dry. Dred Scott is the most needed arsenal in regards to your ability to be able to fight off these these people who are claimed to have an interest in land that do not belong to them. All right. So understand what you have to work with. You know, English people is all it's been in your hands ever since time immemorial. Okay. So understand what you're working with. I love you all, and I love my English people. I love my English subject. I love my English heirs. And with that, from the English 30 People Church of England, we say